Ajit?
Yes, sir. Good morning, sir.
All are ready? Good morning.
Yes, sir. Yes, sir.
So we start now. Just ensure whether all resource persons are joined. Okay?
Yes, sir. Yes, sir.
Please unmute all resource persons and host Dr. Dashat sir, Jyoti Vishwanath, Chandrakanti.
Yes, yes, sir. We are co-hosted.
Subramanya sir has to come this side.
Sir will be joining in a minute, sir.
Okay.
Okay. Shall we start now?
ಒಂದು ನಿಮಿಷ ದಶರಥ್ ಸರ್ ಟೆಸ್ಟ್ ಮಾಡಿ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ?
Hello.
ಕೇಳಿಸ್ತಾ ಇದೆ ಸರ್?
Good morning, sir. Good morning, sir.
Good morning. Good morning.
Good morning.
Good morning, sir. ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ನಾಡಗೌಡ sir, Professor Sudesh.
Yes, sir. Thank you. Good morning to you all.
Good morning to all. 248 participants ಇದ್ದಾರೆ. That is better than physical conferences. So we start.
Okay.
Dr. Satish.
Sir.
Let Subramanya sir join.
Yeah.
ಅಲ್ಲ ಅವರಿಗೆ ಸರ್ ಒಂದು ಫೋನ್ ಮಾಡಿ ಕೇಳಿ ವೆದರ್
ಅಲ್ಲಿ ಲೀವ್ ಅಂತ ಮಾಡ್ಬೇಕಷ್ಟೇ.
ಅದೇ he has any difficulty to switch over from there to here. Okay, now sir has come.
Yeah.
Subramanya sir, shall we start?
Unmute ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಸರ್. ಪ್ರೊಫೆಸರ್ ಅನ್ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ.
Ajit, shall we start now?
Yes, sir. Mahima will be the
Yeah,
MC,
please
sir.
proceed.
Mahima, go. Please proceed.
Yeah. Proceed.
Am I audible?
Yes, Mahima.
Subramanya sir, shall we start? ಅವ್ರು ಕೇಳ್ತಾ ಕಾಣಿಸ್ತದೆ.
ಇದಾರೆ ಸರ್.
Okay, right.
Okay, thank you, sir. Ladies and gentlemen, a very good morning to one and all present here. I, Mahima Nayak, student of University Law College, Bangalore University, will be a host for this session of the 2-day international virtual workshop on protection of human rights during the pandemic. I would like to extend my humble greetings to the esteemed dignitaries, guests, and delegates who are a part of this workshop. After the enriching sessions of day 1, we have now successfully arrived at day 2 of the workshop. It is an immense pleasure and privilege to introduce you all to the prominent speakers we have with us today. Professor Dr. T.R. Subramanya, Dean of School of Legal Studies, CMR University, will be the chairperson of this session. Professor Dr. G.B. Reddy, Professor and former Dean of Faculty of Law, Osmania University, Hyderabad. Dr. P. Puneet, Associate Professor of Law in Center for the Study of Law and Governance, JNU, New Delhi. And Dr. Anish V. Pillai, Faculty in School of Legal Studies, Cochin University of Science and Technology, Kerala. We also have with us the director of the workshop, Professor Dr. Suresh V. Nadagaudar, Principal of University Law College, Bangalore University. The co-directors of this workshop, Professor Dr. V. Sudesh, former Principal and Dean of University Law College, Department of Studies in Law, Bangalore University. Professor Dr. N. Dasharath, Chairman of Department of Studies in Law and Dean, Faculty of Law, Bangalore University. And the coordinator for today's event, Dr. N. Satish Gowda, Senior Assistant Professor of University Law College, Bangalore University. Now I would like to invite Dr. Jyoti Vishwanath, Senior Assistant Professor of University Law College, Bangalore University, to welcome the dignitaries and the gathering. Over to you, ma'am.
Very good morning to everyone and all. It's my extreme pleasure to invite and welcome all the virtual gathering present here to the second day of the International Virtual Workshop on Protection of Human Rights during Pandemic. We have to start the third session. I welcome Professor Dr. T.R. Subramanya, Dean, School of Legal Studies, CMR University, and former Vice Chancellor, KSLE Hubli. I also welcome to the gathering, sir. I welcome Professor Dr. G.B. Reddy, Professor and former Dean, Faculty of Law, Osmania University, Hyderabad, to the third session. Welcome, sir. I welcome Dr. P. Puneet, Associate Professor of Law, Center for the Study of Law and Governance, JNU, New Delhi, Welcome to the session, Puneet. I welcome Dr. Anish V. Pillai, Faculty of Law, School of Legal Studies, Cochin University of Science and Technology. Welcome to the session, sir. I also take the extreme pleasure of welcoming our own beloved principal, Dr. Suresh V. Nadagowda, to the third session. I also welcome our Chairman and Dean, Faculty of Law, Dr. N. Dashrath, to the third session of the international seminar. I also welcome our professor, beloved professor, Dr. V. Sudesh, and former in charge Vice Chancellor of Bangalore University, to the third session. I also welcome our coordinator, Dr. N. Satish Gowda, and our other colleagues, Dr. Chandrakanti and Dr. Shivkumari Madam, to the present session. I also take the opportunity to welcome our teaching and non-teaching faculty to the program. I also welcome our LLB, LLM students, our esteemed audience, and the participants and the delegates of the International Virtual Seminar to this third session. I hope the session will be as magnificent as the earlier two sessions were. Good morning to everybody. Thank you and welcome.
Thank you, ma'am, for the warm welcome. Towards the end of this session, we will have an interactive question and answer session. I request you all to submit your questions to the chat box of the co-host, Mr. Satyajit MS. Without further ado, I'd like to invite Professor Dr. T.R. Subramanya, chairperson of this workshop. Sir has obtained MPhil and PhD degree in international law from the School of International Studies, JNU, New Delhi. Sir was the Vice Chancellor of KSLU Hubballi, and Sir has also been the in-charge Vice Chancellor of Bangalore University, Dean and Chairman of the Faculty of Law, Bangalore University. In the international level, Sir has served as legal advisor to the Kingdom of Bahrain for over 7 years. In this capacity, Sir acquired considerable knowledge of the laws and legal systems of the Gulf Cooperation Council states and in the practical application of international law at the municipal level. Sir is currently serving as the Dean of CMR University, School of Legal Studies, Bengaluru. Over to you, sir.
Dear Professor Nadagowda, Principal of the University Law College, Dr. Sudesh, Professor Dashrath, Dr. Puneet, Professor B.B. Reddy, Professor Anish, Dr. Satish Gowda, and Madam Jyoti, and the faculty members of the University Law College, as well as the non-teaching members of the faculty, and dear learned listeners and scholars. When we actually speak about human rights, just like the idea of parliamentary democracy, or of Marxist political theory, or of the idea of science-based technology, the concept of human rights has gained and gaining and will gain momentum in the years ahead. It has championed the cause right from the time of the Roman period, the Greek period, thereafterwards in the Christian era, and the 16th as well as the 19th and 20th centuries. Now, when we discuss into the provisions of Charter of United Nations, for the first time, the Charter, could you hear?
Yes, sir. Yes,
Can
sir.
you hear?
Yes, sir.
Yes, sir.
Sir, please continue.
Under the Charter of United Nations, the human rights provisions were discussed under Article 1, Paragraph 3, which naturally speaks about non-discrimination. There cannot be discrimination of any type based on race, sex, and place of birth. Then the other provisions were spoken under Article 55 as well as 56 of the Charter of the United Nations. Now a debate came in, and in this debate before the International Law Commission, whether the human rights provisions of the Charter of United Nations are binding. So at this time, during the course of the debate, there were two groups of thought. One group led by Mr. Manley O. Hudson, a senior scholar in the area of international law and a senior member of the International Law Commission. He said, the Charter of United Nations only request the states to cooperate. So it is the duty of the states to cooperate and have pledged cooperation, thus far no further. And if any state were to say, or if any scholar were to insist that the human rights provisions of Charter of United Nations creates a binding obligation, remember the Charter of the United Nations will disintegrate. This is the expression among scholars. However, he was equally supported by Mr. Hans Kelsen. Hans Kelsen, in his pure theory of law, went to the extent of pointing out the Charter obligations on human rights are not binding. Under no circumstances, the states can be forced and enforce the provisions of human rights unless and until an amendment to the Charter is adopted thereby. But then, the other school of thought, which was led by Professor Harsh Lauterpacht, he was the man who championed the cause of human rights. And in the year 1946 itself, he wrote a book on international human rights. He went to the extent of pointing out that Charter provisions are binding and it has to be respected. It had to be adhered by states. It has to be enforced by states through the machinery of the United Nations as well as the agencies of the state. He was equally supported by Justice Philip Jessup as well as Justice Professor Philip Jessup, who later became the judge of the International Court of Justice, and Professor Quincy Wright, an eminent scholar in the area of international law. Now, they were just quoting only one provision of the Charter of United Nations. Under Article 56, paragraph 2, the provision reads thus: each member of the state is supposed to take a joint and separate action. Each member of the state is supposed to take joint and separate action for the enforcement of the provisions of the rights which are human, enshrined in the provisions of the Charter of United Nations. What does it mean? United Nations is a major multilateral treaty, and to which almost all the states today, there are as many as 194 states who are members of the United Nations. They are supposed to respect the provisions of human rights. Now, when these things came in, there was a question, which human rights? The Charter of United Nations does not specify human rights. And when it did not specify human rights, naturally they wanted to have the specification of the rights which are to be protected under. Then came the Universal Declaration of Human Rights. Universal Declaration of Human Rights came in the year 1948. And remember, the first 21 articles speaks about the civil and political rights. Right to freedom of thought and expression, right to movement, right to asylum, right to nationality, right to freedom from torture and degrading human treatment. All these rights are being spoken from between 1 to 21. Thereafterwards, Article 22 to 27 naturally speaks about the economic, social, and cultural rights, religious freedom, freedom to form trade unions, freedom to form associations. All of them were spoken there. Now, when we go to this, a question came again, whether the Universal Declaration of Human Rights is binding. Now, I don't want to elaborate much, only I shall give the opinion of Lord Denning. Lord Denning, in one of his judgments, under the Universal Declaration, there are no litigants. Under the Universal Declaration of Human Rights, you cannot book a case. Under the Universal Declaration of Human Rights, nobody can be tried. So with the result, it is a useless document. So the members of the United Nations, soon after the judgment, realized the gravity of the situation and the pulse of the problem. And immediately they requested the United Nations Commission of Human Rights to draft the Convention on Civil and Political Rights. I can just tell you, the Convention on Civil and Political Rights was drafted in 1952. But the conduct and attitude of the states was slow, so slow. It took as many as 14 years to be introduced in the United Nations. It was in 1966, the Convention on Civil and Political Rights, as well as the Convention on Economic, Social, and Cultural Rights were introduced under the Charter of United Nations. Now, the one other instance happened to be in 1940, President Roosevelt as well as Mr. Churchill, the Prime Minister of England, they met in a battleship in the Atlantic. When they met in a battleship in an Atlantic, they pointed out that the Axis powers led by Germany, Japan, and Italy have destroyed basic human rights. And these basic human rights are to be protected, and it should be the concern of the allied powers, led by the state of United States, United Kingdom, Soviet Russia, and the state of France. Now they just said there are 4 rights which are in danger today. Now these 4 rights are, the first one is freedom of thought and expression, freedom to worship God, freedom from fear, and freedom from want. Now apply this today's analogy. People are living in fear and they are not in a position to go out. And most of the channels, they actually terrorize them. This is going to happen, that is going to happen, don't move, don't talk, don't mix. No, again, it is a basic violation of human rights under the present day. Now, freedom to worship God. What is it that the state government has done? People are not allowed to go to temples. People are not allowed to worship. And both fear what certain things will be or the patients. This is how things are being mixed. Now, when we actually come to the protection and promotion of human rights, I'll just take 2-3 minutes. The 2 legislations are very important. One legislation is the academic 1987 National Disaster Management Act of 1897. Most of the scholars, when they speak, they only speak about Section 2A. That is, the central government is empowered to enact any type of legislation and keep the existing legislations which are in force under suspension. But then there is one more section, Section 2, which actually empowers the state governments to do what they want to overcome from the epidemic. The state government is empowered to search any vehicle, any prevention of movement of the people. And even in railway stations, they can keep people and just turn them away. And they have the power under Section 2 to keep the people under quarantine. Now, this is a major legislation which is being enacted, although it was enforced by the British government then, 120 years ago. Then we have the other legislation, the legislation which is National Disaster Management Act. First and foremost, we should remember the National Disaster Management Act was enacted for a disaster. It was not enacted to overcome the issues relating to public health. And it is not enacted to overcome the issues relating to environment. For the first time in the history, an amendment was brought. And after this, it was made applicable to the issues on public health. And the rest, all of you know what is happening. I request the learned speakers to talk essentially on the basic aspects of the topic and conclude. I request the speakers to come forward and speak.
Thank you, sir.
Thank you, sir, for the thoughtful speech. I would like to invite Professor Dr. G.B. Reddy. Sir is a lawyer turned academician who has studied BA LLB, LLM, and has obtained PhD in law from Osmania University. Sir's area of specialization is constitutional law in LLM and judicial activism in PhD, and has specialized in the area of intellectual property as an independent researcher, publisher, and teacher. Sir has had a brilliant academic record with 3 gold medals in LLB and 1 gold medal in LLM. Sir has practiced in High Court of Andhra Pradesh for about 7 years before joining the Faculty of Law, Osmania University. Sir has authored 20 well-received books on law and published 56 articles on law in standard national and international journals. At present, Sir is the Director of University Foreign Relations Office, Osmania University. Sir is also the Chairperson of Board of Studies in Law, Osmania University. Sir will be addressing the topic Judicial Response to Ensure Human Rights During COVID-19. Over to you, sir.
Thank you. Professor T.R. Subramania, the chairperson of the session, and all my learned friends from the Faculty of Law, Professor S.V. Nadagowda, Professor Sudesh, Professor Dashrath, Dr. Puneet, Dr. Anish Pillai, Professor Jyoti Vishwanath, and Professor Satish Gowda, and other faculty members, participants, and friends. In fact, my task is made simple by Professor Subramania, who traced the evolution of human rights under international law and their institutionalization in international charters like International Covenants of 1966. Well, during COVID period, all the three organs of the state are expected to play an active role in protection of human rights. And how the political organs of the state have responded is there for all to see. The legislature as well as the executive. Probably the legislature has not done anything, but the governments of the day, they have been, trying to invoke either Indian Penal Code or the Epidemic Diseases Act or the National Disaster Management Act, so on and so forth. And in the process, we have come to witness a tussle between various human rights also, like right to life versus right to livelihood, then freedom of movement, then right to privacy, right to treatment, sometimes even right to die with dignity or right to be buried with dignity. These are some of the important issues. And as far as the protection of human rights is concerned, the judiciary's record has been almost impeccable since 1978 or so. That is from Maneka Gandhi's judgment. And the Supreme Lex Loci, that is the Constitution of India, has already anointed the Supreme Court as the protector of fundamental rights, which are the human rights incorporated in the Constitution. And a scheme under Article 32, 141 and 142, etc., clearly makes that point. Similarly, yesteryears witnessed immense contribution from great judges or champions of human rights, like Justice Krishna Iyer. Before that, Justice H.R. Khanna. In fact, both of them were contemporaries. And Justice P.N. Bhagwati. Unfortunately, you don't come across such benevolent, progressive, and human rights conscious judges in great numbers nowadays. They go by the rule of law. And the journey from Maneka Gandhi's case in 1978 has been fascinating. We have seen right to life becoming right to live with basic human dignity, then encompassing within it or its fold a variety of rights, number of rights which are implicit. Some of them became, explicit fundamental rights like right to free and compulsory education by way of 86th Amendment 2002, and many more, even though they remain, only judicially recognized fundamental rights, they have their own significance. What I am trying to look at is the emergence of new human rights jurisprudence after 1980s. And today it encompasses the right to live with basic human dignity, the right to health, which is more important in the, during the present COVID pandemic, the right to livelihood, which is also equally important, and even right to die with dignity. We need not mention about all those cases. The list will be endless, because our primary concern is to look at the judicial response during COVID. So let's say from March onwards, or maybe, February onwards. Then another important aspect which I have seen is that in the good old days, the suspension of fundamental rights during emergency was upheld. In fact, all the fundamental rights operation was suspended or could be suspended those days prior to 44th Amendment 1978. And the 4 majority judges' opinion in habeas corpus case of 1978, with the lonely dissenting judgment of Justice H.R. Khanna, came to be specifically overruled only in 2017 in the 9 judges bench decision on right to privacy in the case filed by Justice K.S. Puttaswamy retired. And one has to look at what Justice D.Y. Chandrachud, remarked on that particular point as part of his judgment. Be that as it may, what we are, hinting is a shift which has been witnessed, and how the protection of human rights during normal times should be viewed as different from the extraordinary situations, like where there can be an unwritten health emergency or sometimes even war emergency. But health emergency is something, which is only mentioned in enactments like the Patents Act of 1970, where health emergency could be imposed on specific grounds. Some of the, the left parties always demand imposition of health emergency. Probably there's nothing wrong in it, especially this is a fit case where health emergency ought to have been, imposed. It has got nothing to do with financial emergency there. Now, coming to the impact of COVID-19 pandemic on various human rights, I must say that almost every human right has been impacted. COVID has impacted right to life, because in the absence of any proper treatment, proper testing, proper tracing, certainly the life is threatened. Life of not one individual, but all the family members, members of the society. Here there is no discrimination between the rich and poor. Right to life is the most or the worst affected human right, I must say. Then right to livelihood, we'll try to discuss in the context of the plight of the migrant laborers. Those persons who went from one state to other in search of livelihood to work in construction industry or some other industries, when they lost their livelihood, when they wanted to go back to their countries, their states, then how, the various restrictions were imposed. And here I think even judiciary also must be blamed. Initially, its response has been lackadaisical, indifferent. Only subsequently, a suo motu petition was taken up. Right to education. Honestly speaking, right to education is the worst affected human right during COVID times. Thankfully, the technology is trying to supplement, not substitute, what the student or researcher could have got during normal times. And today, the tests are imposed, the tests are not conducted, they're postponed. And in fact, the regular exams are not conducted. They say that, we will promote you based on the previous performance. UGC has come out with, certain guidelines 2 times. So today tests appear to be compulsory, offline, online, or a combination of both. School children are, compelled to attend video classes, and collection of huge amounts of money is clearly violative of Article 21A. And in fact, recently, the High Court of Telangana has pulled up the state government as well as the private educational institutions, which have been collecting huge amounts of money from toddlers in the name of video lessons. Be that as it may, right from the children between 6 to 14 years, even the others' right to education also is affected, which is implicit, of course. Right to privacy. This is something, in fact, which is the worst affected, I must say. And some of my friends told me that when they check into government Gandhi hospital, they are assigned only numbers. They don't have any names. So the person is assigned only number in order to protect his privacy, but there is no attention paid to him. So number checks in, number comes out, mostly without any life. And right to privacy also is, in fact, violated, especially when areas are cordoned off, police checkposts are, installed near certain residences, then movement is restricted. The people are simply, in fact, put at a distance. It's a kind of new untouchability which has come up. Very unfortunate. Even, the death of the person is not invoking the human emotions. That is the most unfortunate aspect. Right to privacy of patients, their family members, and others. Freedom of movement is worst affected. Naturally, it will be affected. In the larger interest, certainly it can be restricted, but still it is affected. Right to health and right to treatment. Plethora of cases have been decided by the Supreme Court and various high courts. Right from Consumer Education Research Center versus Union of India, 1995, the asbestosis case, some cases prior to that, some cases later. And now it is recognized that right to health is part of the right to life under Article 21. That is affected. Sometimes, the citizens find themselves in a big dilemma. Nobody conducts any tests. Then, in fact, even any tests are conducted, the results come very late. Even if the results come, most of them are, in fact, faulty results. They're changed from positive to negative or negative to positive. And even if a person is found positive, there are no private hospitals, there are no sufficient beds and other ventilators. Doctors themselves are trying to, in fact, protect themselves without any personal protection kits, whatever it is. So right to treatment is denied, right to health is denied. Right to decent burial is denied. You know very well, in law of torts also we say that dead persons also have certain rights. One of them is right to decent burial. But what's happening? Proclaimers are dumping the dead bodies. The family members are simply running away from the dead bodies. And there is no decent burial. Only few, voluntary organizations are coming forward. Otherwise, even family members are afraid. This is the point. Right to freedom of religion is affected. Right to worship. So I will, in fact, I have chosen 8 cases decided by the Supreme Court and various high courts. Supreme Court has responded very guardingly on this particular issue. I'm not on the freedom of religion, but on the violation of human rights during COVID. But many high courts have responded to a great extent. Right to residence. Recently, I have read a newspaper item in Times of India. In Bangalore only, in fact, the husband refused entry of his wife who was away in Chandigarh for 3 months because she was held up there because of the lockdown. And when she came back after 3 months with great difficulty, she expected a wonderful welcome. Instead, the husband says, you should not enter the house. You quarantine yourself for 14 days. After that, you get yourself tested. Then only when it is negative, then you come in. And when she complained to the police, when the police went there, he locked the house and fled himself along with his 10-year-old boy. Where should the women go? What happened to the human relations and emotions? This is the point. Of course, it's not because of, the state violation, but because of the human, relations and the changing dynamics of human relations. right to die with dignity also is one of them. In fact, sometimes euthanasia is administered by not the dying person refusing treatment, but by those persons who are making a request like don't escalate treatment. That's what they say. In Bombay, it is quite common, it appears. This is one aspect. As I already mentioned, there are a number of judgments. I will not touch upon all of them. Time doesn't permit because I have another 10 minutes. Now, when we look at some of the important cases, the most important cases appear to be on right to treatment, right to get, hospital beds, so on and so forth. There is one judgment given by a division bench of Telangana High Court in a case called Ganta Jaikumar versus State of Telangana. This judgment was given about 2 months back on 20th May. And two judges, Justice M.S. Ramchandra Rao and Justice Lakshman K., they emphasize the importance of private sector in dealing with COVID. I'll give you the brief gist of facts. The government of Telangana initially identified only 1 or 2 government hospitals to treat COVID patients, to admit them and to treat them. In Hyderabad, that too. Then there was a lot of demand saying that the beds are not sufficient. And, in fact, there is a rise in the positive cases. So testing has to be done even by ICMR approved private laboratories, diagnostic centers. In fact, ICMR has already furnished a list. Similarly, treatment also may be given by adhering to ICMR protocols. Initially, they said only few private hospitals and diagnostic centers will be permitted. They issued an order. Later on, they said, in fact, no private hospital will admit a patient. Similarly, no private testing will be done. So only Gandhi Hospital, Mahatma Gandhi will take care of everyone. This was the issue. Then a public interest litigation was filed, of course, which was criticized by the Advocate General, saying that it is induced by the corporate hospitals. But the person says that, I'm not interested in going to corporate hospital. Let any small hospital equipped with the machinery and wherewithal to treat may be permitted. And here the main issue is this, whether the state government can compel the residents and citizens of the state of Telangana to get one, testing for COVID in only NIMS. We have Nizam Institute of Medical Sciences, a government hospital, or Gandhi Medical Hospital, or only in other designated laboratories decided by them. Can the government say, you go and take treatment only in these hospitals, mostly government hospitals? The second one is the treatment and isolation. Whether the treatment of patient and their isolation should be done only in these designated hospitals, especially when the conditions in government hospitals are so bad. And when the citizens are willing to pay the charges for getting themselves tested and treated in private hospitals. This is the point. And the division bench of the High Court ultimately came out with, in fact, it's a scholarly judgment. Kindly read Ganta Jaikumar versus State of Telangana. Ultimately, the Telangana High Court declared that the government has no power either under the Epidemic Diseases Act or under any other law for the time being to compel the patients only to be treated in a particular hospital, especially when other hospitals are available and the patients are ready to be treated, tested and treated in other hospitals. So right to treatment, right to health, both of them are emphasized in this particular case. And the Telangana High Court also referred to ICMR guidelines and the mention about the constructive role that can be played even by the private sector. This is one, but very unfortunate aspect is that government is frowning upon the huge fees collected by various private hospitals, which is a good thing. But so far, no guidelines have been given. And the talk in Hyderabad and Bangalore is that if you are ready to pay 1.5 lakh to 2 lakh rupees per day, you will get hospital bed in any corporate hospital. But how many people can really in fact, afford to pay 2 lakh rupees per day. I think this is where the government has failed. The courts have not responded properly. This is one particular case. Then there is another important case. We say human rights include right to life, which include right to food also. Now, many governments have, very pompously announced that we are going to give 5 rupee, 5 kgs rice to every human being, every citizen resident residing in that particular state. Fact is that you have National Food Security Act of 2013, and which entitles certain persons to, in fact, to free rice and other essential commodities as far as the food items are concerned. In one case called the Human Rights Alert versus State of Manipur, and this was a case decided on 13th May by a division bench of the Manipur High Court. A PAL was filed to ensure proper distribution of the essential commodities at the prices fixed by the government, and also to make necessary arrangement for availability of essential commodities to the public, including the right to receive the rice and all. And the High Court has noted the scheme under the National Food Security Act, then the difficulties faced by many poor people during the lockdown declared by the PM on 25th March, and ultimately directed the identification of eligible households district-wise to receive essential commodities. Again, for making the details of the beneficiaries, the agencies like fair price shops and officials and grievous redressal mechanism available to public through websites. And one good thing is that the court said even non-card holders under this NFSCA, National Food Security Act, are also supposed to be given rice free of cost, because the Chief Minister said it will be given free of cost. So right to food is one of the issues which was sought to be protected by judicial intervention. Then the Supreme Court's response came only in one conspicuous judgment, that is INRI, Problems and Miseries of Migrant Laborers, wherein a 3 judges bench of the Supreme Court dated 9th June 2020, almost a month back. And this was because of number of writ petitions filed and even intervention of National Human Rights Commission under the Protection of Human Rights Act before the Supreme Court. And it is about the stranded migrant workers. As I mentioned in the beginning, migrant workers, who are stranded in different states. The problem was that they were willing to go back to their, native states, but there was no possibility of any journey or process because most of the public transport came to stand still. So the government railway ultimately decided to run some Shramik trains, Shramik rails, on the request of some of the state governments also. So the court says that even in terms of the, the Epidemic Diseases Act or whatever, these migrant laborers, they have a right to reach their home, and it is the duty of the government to ensure that they reach home by using the facility provided by the government. So the Supreme Court also directed the states to establish counseling centers, help desks at block and district level, so on and so forth. I think after this judgment only, the problem of migrant workers came to a standstill. And in fact, in some states, migrant laborers revolted. They were ready to revolt even against the police because they were not allowing him to leave the place on many grounds. And similarly, one more point, suppose those people who violated the lockdown guidelines, like coming onto the roads, trying to reach some other place, maybe either on foot or, maybe using various devices, including some innovative devices. So the Supreme Court directed the states and union territories to consider withdrawal of prosecution and also complaints under Section 51 of the Disaster Management Act and other related offenses. So this is also one good thing. But Supreme Court's decision could be, criticized for its late response and directions only on the lines of information given by the union and state governments. This is another one. Then yet another important case is from Maharashtra. In fact, a single judge, she took suo motu cognizance of certain newspaper reports regarding the detention of certain laborers traveling from Pune to Ahmednagar to Madhya Pradesh. Then similarly, insufficient protection of the health workers. This is very important. If the protector himself or herself is not protected, how do you expect them to protect the health of common man? Then a message circulated on social media platform. In this particular judgment dated 8th April 2020, the learned single judge, Justice Prasanna B. Varale, emphasized on fundamental duties also. I think this is the most sorry state of affairs now. We are talking about human rights, but human duties have failed miserably. And there the Supreme Court, the High Court of Bombay, referred to two fundamental duties of every citizen: to promote harmony and spirit of common brotherhood, and to develop the scientific temper, humanism, and spirit of inquiry. Unfortunately, these human duties or fundamental duties are not really, considered seriously. There is one more judgment, Suo Moto versus State of Gujarat, dated 27th March 2020. Main issue is, of course, in fact, everything under the sky was sought in a series of petitions before the, State of Gujarat, and State of Gujarat also took suo moto cognizance of the same. But based on the guidelines given by other high courts like Allahabad High Court, Bombay, Calcutta, Kerala, and Madras High Courts, the Gujarat High Court issued a direction to the Department of Home, Government of Gujarat, to consider the aspect of, in fact, not arresting the accused if it is permitted under the law. Second one, even if he is arrested, not to send them to jail without conducting the corona tests. This is important. So the main purpose was not to mingle the untested accused for corona with those who are already languishing in jail. So, like, separating the under trials from the convicted persons. Then there is one more very important issue is Kerala High Court. It was confronted with the issue of conducting NEET. The NEET is, very well, National Eligibility Entrance Test for medical admissions throughout the country. And the contention in the case of Abdul Aziz versus Union of India, and the judgment was given on 30th June, about 11 days back from today, where the petitioner's argument was that arrangement must be made to, in fact, conduct NEET test in Gulf countries. Gulf countries, this is very important, where, number of Indian people, Qatar as well as the Gulf countries, Gulf cooperation countries. And, but the High Court of Kerala ultimately held that as far as these tests are concerned, MCI, that is Medical Council of India, and National Testing Agency, they are the competent bodies, they are the examining bodies. Therefore, they must take a call on this, and there can't be any, relief to give a direction to the respondents to conduct the test. Vande Bharat mission was also sought to be introduced in this, but the High Court was not really, happy. On freedom of religion, a very peculiar case. Salman Khurshid, the former Union Law Minister, he wanted, in fact, one of his juniors probably, based on a letter by Salman Khurshid, he challenged the validity of the prohibitory orders on azan. Azan means, calling the Muslim believers to come and offer prayers in the concerned mosque, nearby mosque, by using loudspeakers. So, in the case of Afzal Ansari versus State of UP, dated 15th May 2020, and a division bench of the Allahabad High Court held that azan can be recited by muezzin from minarets of the mosque by human voice, not by using amplifying devices like loudspeakers, so on and so forth. This is one. And they say that azan may be essential and integral part of Islam, but recitation of azan through loudspeakers or other sound amplifying devices cannot be an integral part of religion. So, point is, wherever you are, you can pray, and muezzin who recites azan, then he may use only human voice. So maybe, during COVID times, and of course, the court also referred to number of Supreme Court judgments, including in the noise pollution 2005. I'll take another 2 minutes and stop. Another important case is about, for example, I mentioned about the impact of COVID on freedom of movement. You come across many people roaming on the roads even without any purpose. This is India. And in fact, there was a viral video also pertaining to Madras, where the police, they shot a video. So, using some actors or maybe some amateurs, wherein 2 or 3 persons roaming on a bike will be caught hold. Then ultimately they are sought to be pushed into a medical van or ambulance where corona patients are waiting. These people try to run away and all. Similar situation came up in Madras in the case called ML Ravi versus Principal Secretary, Home Department, Tamil Nadu. The decision was rendered on 18th May 2020 by 2 judges. The writ petition prayed for issue of guidelines to the police personnel not to infringe the human rights during the curfew. Maybe, the petitioners wanted their freedom of movement to be protected, but the High Court held that citizens are supposed to be aware of their duties and responsibilities. They are not expected to roam around freely like ordinary times during this COVID-19 pandemic virus period. And therefore, as and when they violate the law and order machinery will definitely take care of their, action. This is one. Then, of course, there are any number of cases. But to conclude, what I will try to say is that when you analyze the judicial trends, because I have seen about nearly 25, 30 judgments, I found that there is not much judicial activism witnessed for the protection of human rights, maybe because economics is involved, finances are involved, courts are ill-equipped. They can give directions from time to time. This is one point. And however, they are not insensitive also at the same time. Most of the directions are pragmatic as per the existing laws. And as I already said, some high courts simply jumped the queue, like Telangana High Court. When nearly 5 lakh people, precisely 4,68,000 people registered themselves for various common entrance tests, none of the applicant approached the court asking for postponement, but on a petition filed by someone else who was not even an applicant in the name of public interest litigation, they extracted an assurance from the state government that the test will not be conducted, expecting lockdown. These guidelines were given, this interim order was given 10 days back. By this time, most of the tests would have been conducted by taking necessary precautions. Whatever, this is another important issue. What we need is a proactive response from the courts, especially in the context of a cap which is directed to be put on the massive fees collected from the patients. This is another one. Then another important aspect is, point is very simple, sir. When the governments are insensitive, when the governments are more particular about getting more taxes by opening liquor and wine shops, right? And who will come to our rescue? Naturally, we look to the courts, and it is only the last resort. We are not asking for judicial governance. At the same time, the courts are expected to play a more active role. This is the point. So we are expecting some kind of more activism, dynamism from the courts while dealing with this COVID pandemic, whether it is burial, whether it is testing, tracing, whatever. Another important point, abandonment of dead bodies. I already mentioned. Courts, sometimes they gave directions. And last point, request not to escalate treatment in certain cases. From Bombay, it has been reported that many family members who admitted their kith and kin in the hospitals for corona, they have been requesting doctors not to put them on ventilators, not to give oxygen, right? And not to give any other treatment, fully knowing that they are suffering from some kind of comorbidity or maybe because of economic factors, financial incapacity. What I'm trying to say is that what the Supreme Court said in, in fact, People Union for Civil Liberties case regarding the right to die with human dignity and passive euthanasia was, recognized. A right to die with human dignity is recognized. Unfortunately, they are applying this here. There may be a possibility of revival of that person. Unfortunately, neither the governments are not doing much, the courts are also insensitive. Nonetheless, to conclude, I must say that judiciary has responded, though not on the expected lines. We expected, some more dynamism, some more, in fact, courage in the judicial decisions. But at the same time, in the given situation, they have to strike a balance between various aspects like right to life, right to livelihood, so on and so forth. On that count, judiciary has done well. So I'll take this opportunity to thank all my friends in Bangalore University for giving me this wonderful opportunity, and also to thank all the participants for your patient hearing. Thank you very much. I'll stop. I'll be remaining online for the next sessions. Thank you very much.
Thank you very much, sir, for sparing your valuable time and delivering a very informative speech.
Thank you. Thank you.
Thank you, sir, for your valuable insights. It was indeed a thought-provoking speech. Now, I would like to invite Dr. P. Puneet. Sir has completed his education, that is BA LLB, LLM, and PhD from Bangalore University. Sir's teaching and research areas of interest are constitution and administrative law, judicial process, judicial administration, human rights, and criminal law. Sir is a regular contributor for the annual survey of Indian law and also has published papers in journals of national and international repute. Sir is currently the Associate Professor of Law in the Center for the Study of Law and Governance, Jawaharlal Nehru University, New Delhi. Sir will be addressing the topic invoking penal laws for tackling COVID-19 and human rights concerns. Over to you, sir.
Thank you, Mahima, for the kind introduction, and very good morning to you all. Respected Chair, Professor Dr. T.R. Subramania, distinguished co-speakers, Professor G.B. Reddy and Dr. Anis Pillai, my esteemed teachers, Professor V. Sudesh, Dr. N. Dashrath, the principal and the director of the event, Professor S.P. Nadagowda, the coordinator, Dr. Satishan Gowda, Dr. Jyoti Vishwanathan, other members of the faculty, students, and participants. It is always a great pleasure to be part of any of the academic event organized by one's own alma mater. At the outset, I thank the organizers for giving me this opportunity. The topic I have chosen is invoking penal laws for tackling COVID-19 human rights concerns. Though it appears to be somewhat broad, my focus would be on the question as to whether the laws that are being invoked, which are either essentially penal in nature or contain penal provisions, do conform to the constitutional framework or standards envisaged for the protection of human rights in India. Given the current climate in the country, one might ask, is this the right time to raise such a question? Let me answer that in the first place. It is important for us to understand that the constitutional standards are to be complied with not only when the going is good, but even when the going is tough. Crises like this put to test our commitment to constitutional ideals and values. And the constitutional mandate are non-negotiable under every circumstances, except to the extent to which the Constitution itself permits deviations under certain circumstances. The adage, necessity knows no law, has no place in a democratic constitution. That is the premise with which I would like to proceed further. I have divided my paper into 3 parts. In the first part, I will briefly, perhaps very briefly, talk about the constitutional framework envisaged for the protection of fundamental rights in India. In the second part, I'll give you a broad overview of penal laws, both substantive and procedural laws that are being invoked to tackle the COVID-19 pandemic. And in the third, I'll flag some of the human rights concerns. As we all know, the Constitution of India has not only recognized fundamental rights, It also provided proper framework for effectively safeguarding and implementing them. Mere recognition of fundamental rights without a proper framework for their protection and enforcement would be hardly of any significance. Adherence to rule of law, principles of separation of power and judicial review, all of which are considered to be part of the basic structure of the Constitution in India, are very important for effectively safeguarding the fundamental rights. Given the fact that in some of the law schools, they're being taught as distinct topics, as if there is no connection between them and the fundamental rights, we often do not realize and appreciate their importance fully in safeguarding the fundamental rights. Rule of law, separation of powers, and judicial review are closely connected, and they operate together to ensure that no person shall be deprived of his rights or liberties except pursuant to the coordinated efforts of the separate institutions that make, execute, and adjudicate claims under the law. It is important for us to understand that under the scheme of the Indian Constitution, any lawful deprivation of rights of any person requires the participation of all the three wings of the state. These basic constitutional principles need to be understood in proper perspective. Take, for example, the theory of separation of power articulated and expounded by Montesquieu. If one looks at this formulation, it is evident that the protection of rights and liberties of the people is the central idea of the theory of separation of power. For he argues that there will be no liberty if the legislative power unites with the executive power. Life and liberty of the subject would be exposed to arbitrary control if the judicial power unites with the legislative power. And if judicial power joins executive power, the judge might behave with violence and oppression. It's abundantly clear that the central idea of the theory of separation of power is protection of individual rights and liberties. And it is this aspect that needs to be borne in mind. In the light of this, we need to understand whether the laws that are being invoked to tackle the pandemic do conform to these constitutional framework or standards. As all of us know, COVID-19 pandemic, which has struck the humankind in an unprecedented way, has no doubt thrown up multifarious challenges for governance at various levels, at local, national, and global level. Owing to the lack of proper plans and preparedness to contain the novel coronavirus, which has allegedly slipped from animal to human in the city of Wuhan in China in the final weeks of 2019, it had swiftly spread to the rest of the world within weeks. The WHO declared it as the public health emergency of international concern on January 30th, and later on March 11th as a pandemic. In India, the government on January 21st started with, as a precautionary measure, thermal screening of passengers traveling from China at select airports. The first case of COVID-19 in the country was reported on January 30, the very day on which the WHO declared it as the public health emergency of international concern. In February, there was no significant rise in the number of cases in India, but in March, their numbers started growing at an alarming rate. In response to that, the union and the state governments have announced various measures to combat and contain further spread of novel coronavirus in the country. The measures included, apart from stepping up thermal scanning at airports, which was initially confined to few of the airports in India to all the airports, they've also started imposing travel and entry restrictions and cancellation of visas, advisories to the people to observe what is ironically called as social distancing instead of physical distancing, and to maintain personal hygiene, closure of schools and colleges, etc. The most drastic measure announced by the union government was the nationwide lockdown with effect from March 24th, initially for a period of 3 weeks and subsequently being extended from time to time. Several states' governments have also imposed curfews by invoking their power under Section 144 of the CRPC in many parts of the country to effectively enforce the complete lockdown. Several notification guidelines and regulations are being issued from time to time under the Disaster Management Act, as well as under the Epidemic Diseases Act of 1897, which is the legislation of the British era. The provisions under the Indian Penal Code, as well as under the Code of Criminal Procedure, have also been invoked to prosecute and punish those who violate such guidelines and regulations. Certain reports indicate that in some states, the governments have even invoked the National Security Act of 1980, which is the prevailing principal legislation relating to preventive detention in the country. Now, preventive detention is contemplated as one of the extraordinary measures. It's invoking for the purpose of detaining person to deal with issues relating to COVID-19 is, in fact, appears to be a very drastic measure. Without elaborating further, let me move on to the constitutional and human rights concerns. As I mentioned, even Professor Subramania also mentioned about these two legislations in the beginning, the Disaster Management Act and the Epidemic Diseases Act, which are being invoked. Whereas the Disaster Management Act is a comprehensive law that provides framework for the governance during both natural and man-made disasters, and it has certain penal provisions. The British era Epidemic Diseases Act is a very short legislation with only 5 sections. It is a skeletal legislation, so to say, that contains no guidelines but confers vast power on the executive to issue directions or to take such measures to prevent the outbreak of epidemic disease or the spread thereof. Section 3 of the Act particularly declares that any disobedience to any regulation or order made under the Act shall be deemed to be an offense under Section 188 of the Indian Penal Code and punishable accordingly. The Indian Penal Code is also a British era legislation that was enacted in 1860 before the Epidemic Diseases Act, which was enacted in 1897. Under Section 188 of the Indian Penal Code, disobedience to order duly promulgated by a public servant is punishable. In essence, it makes non-obedience to the executive order a punishable offense. It, in my opinion, is a classic case of over-criminalization. Unlike the other provisions under the Indian Penal Code, like sections 269, 270, and 271, which can be, and in fact, which have been invoked to tackle COVID-19, Section 188 is too drastic as regards its coverage, though not the punishment. Sections 269, 270, and 271 deal with specific aspects. Section 269 penalizes negligent act likely to spread infection of diseases dangerous to the life. 270 penalizes malignant act likely to spread infection of diseases dangerous to life. Section 271 penalizes disobeying quarantine rules. But Section 188, on the other hand, penalizes disobedience of any order that is duly promulgated by any public servant. The order need not be in writing. The phrase duly promulgated is not defined. And the definition of public servant under Section 21 of the IPC is too vast. An example of its use, or rather abuse by the police during the pandemic, would help us understand it better. As per the newspaper reports, in Noida, in the state of Uttar Pradesh, this provision has been invoked by the police to book people for not installing Arogya Setu app in their mobile phones. Whereas the union government has been time and again saying that it is not mandatory and the people should be advised and not required to install the app, and there are serious privacy issues raised against it. In parts of Uttar Pradesh, criminal cases are being slapped against citizens under Section 188 of the IPC for not installing the app. This is just one example to show these kind of provisions can be abused to coerce people to do or abstain from doing certain acts by issuing orders which may or may not have a legal backing. The threat of possible criminal sanction can be used to seek obedience to every kind of executive orders, particularly because of the phrase duly promulgated does not necessarily mean that every executive order must have a legal pedigree. And even if it is construed to mean that, we have laws like the Epidemic Diseases Act, which is overly vague and broad and confers vast power on the executive without providing for procedural safeguards of scrutiny. It was enacted during the British era when India did not have a constitution with rights and other limitations on the state power. It was valid then when it was enacted and not now. Now we have a constitution with rights and other limitations on the powers of the different organs of the state. And in my opinion, if challenged, the Epidemic Diseases Act of 1897 cannot stand the constitutional scrutiny, and so does the provisions like Section 188 of the Indian Penal Code. Why I say so? The Epidemic Diseases Act excessively delegates legislative power to the executive. There is no essential legislative policy laid down. As I have said, it is just a 5-section legislation, a short piece of legislation, which only says that for the purpose of preventing the outbreak of epidemic disease or further spread, the state executive can issue any regulation or take any measures. And it also confers certain power in the central executive, no doubt. And Section 3 of the Act clearly says if any regulation or guidelines issued under Section 2 or 2A is violated, then it is punishable under Section 188 of the Indian Penal Code. So there is nothing further that you can, nothing more that you can find under the Epidemic Diseases Act. It is a skeletal legislation in true sense. So there is no legislative policy laid down in the Act. The Act does not contemplate scrutiny by the legislature of the regulations promulgated by the executive, which is one of the most essential features, which we find in almost all legislations enacted after the Constitution has brought into force, which provide for delegation of legislative power to the executive. Whereas the delegation of legislative power to the executive is not per se unconstitutional, delegation of essential legislative power to the executive without laying down broad legislative policy and without providing for scrutiny by the competent legislature is violative of the principle of basic structure, one of the principles of basic structure, that is separation of powers, which is broadly envisaged under the Indian Constitution. And it permits delegation of only incidental legislative powers and not essential legislative powers, and that too subject to the scrutiny by the legislature. Look at, for example, even the Disaster Management Act of 2005 itself. It also delegates legislative power to the executive to make rules and regulations, but it lays down essential legislative policy. Perhaps it's one of the comprehensive legislation that is enacted. It lays down essential legislative policy. And it also requires that the rules and regulations so made must be laid before the Parliament for its scrutiny. Thus, in my opinion, the Epidemic Diseases Act 1897 is clearly unconstitutional for conferring excessive legislative power on the executive. And it is axiomatic to state, as Montesquieu argued, that when the legislative and executive powers are united in the same person or in the same body of persons, there can be no liberty because, as he said, the executive may enact tyrannical laws and enforce them in a tyrannical manner. When such a vast power is conferred on the executive, the law does not actually, in essence, define the crime as such. It delegates the essential power of defining the crime by delegating power to make regulations. And the law in advance declares that any violation of any of the regulations or any of the orders going to be issued, remember it is a legislation enacted more than 100 years back, any of the regulations going to be issued is made an offense under Section 188 of the Indian Penal Code and punishable accordingly. So the Epidemic Diseases Act, in the form in which it exists, is a threat to the rights and liberties guaranteed under the Constitution because it leads to a complete fusion of legislative and executive power, which is an antithesis of the separation of power. And the separation of power theory, if you look at and appreciate in proper perspective, exists for the protection of individual rights and liberties. And if there is a concentration of power, that is the greatest threat to the individual rights and liberties that we need to understand. If you look at the constitutional scheme, we have fundamental rights, no doubt, and none of the rights are absolute. They can be curtailed or deprived on certain grounds and under certain circumstances, but it is only through law it can be done. Law there should actually mean that the law enacted by the competent legislature, and the competent legislature cannot delegate an essential legislative power to the executive. And if there is such a delegation, then that is per se unconstitutional. Even though it is a pre-constitutional law, as we know under Article 372 of the Constitution, pre-constitutional laws have been allowed to continue, but made subject to the provisions of the Indian Constitution. And if you look at this particular legislation, which has no safeguards, procedural or substantive, whatsoever against excessive use of delegated legislative power, it cannot be considered to be constitutionally valid by any standards. Similar arguments can also be advanced against provisions like Section 188 of the Indian Penal Code. The imposition of curfews is another important aspect. Many state governments, as I've said, have imposed curfews under Section 144 of the Code of Criminal Procedure. An imposition of curfew imperil many fundamental rights. Many states have imposed curfews for a prolonged period. Sometimes, looking at some of the recent instances, it appears that Section 144 can be used to achieve the same consequences as that of promulgation of emergency under Article 352 of the Constitution of India. There is no need to resort to Article 352 anymore, when much of its purposes can be accomplished under Section 144 of the CRPC. It is more so when the judiciary is reluctant to interfere with the executive orders. Now, if you look at the use of Section 144, is not something that has become very rampant only after the COVID-19 pandemic. Even before, during the CAA protest, or even earlier in some parts of the country, Section 144 has been imposed, particularly the curfew-like orders under Section 144 has been imposed for a prolonged period of time. And the judiciary also has shown reluctance in interfering and scrutinizing the orders issued by the executive imposing curfew, as a result of which the executive could continue curfews for a longer period of time. If one looks at the recent developments that are taking place, one can say that Section 144 has in fact become a statutory equivalent of Article 352, read with Article 358 and 359 of the Constitution of India. The most of the purposes that could have been achieved only after proclamation of emergency under Article 352 of the Constitution and suspending rights under Article 358 and 359 of the Constitution can be achieved by merely resorting to Section 144 to some extent in some parts of the country at least. So now that after the 44th Amendment to the Constitution of India, though it has not become very difficult to proclaim emergency, it has really become difficult to sustain emergency for a longer period of time. That must be the reason as to why the state may not think of even resorting to Article 352 of the Constitution of India, because it's very, very difficult to sustain. But 144 is more easier and does not have as many safeguards as Article 352 of the Constitution has. So it can be resorted to, and if the judiciary is reluctant to scrutinize the imposition of Section 144, curfew particularly under Section 144, and prolonging such orders, then it can undoubtedly become a statutory equivalent of what I said, Article 352 read with Article 358 and 359 of the Constitution of India. It is another biggest human rights concern. No doubt, the Code of Criminal Procedure was enacted in 1973, and it is not a British era legislation, but Section 144 is definitely a British legacy. There was a previous version of it in the earlier Criminal Procedure Code as well, with certain modifications. I guess more or less the provision got incorporated into the Criminal Procedure of Code of 1973, which is now being more extensively used, and that is in fact a greatest threat to the individual rights and liberties. One had to actually examine that is there a justification, because Section 144 can be used for specific purposes, but also can be used for imposing restrictions on public at large. So keeping that in mind, and imposition of restrictions on public at large to that an extent, issuing general orders like this would imperil many fundamental rights. And after the Constitution of India has come into force, it is only in certain cases of emergencies that the individual rights can be completely imperiled, or else it can only be restricted to the extent to which the Constitution explicitly permits. But imposition of curfew completely imperils the fundamental rights like right to movement, right to residence, and many other rights, right to freedom to carry on trade, business, trade, or occupation. Most of the rights get affected when curfew is imposed under Section 144 of the Criminal Procedure Code. Is it in fact constitutionally permissible to resort to Section 144 to issue such general orders of curfew, even after the Constitution has brought into force, particularly when the Constitution has contemplated such an extraordinary measures only in exceptional cases, is something that the legal scholars must actually scrutinize. And in my opinion, it is very important to be addressed, particularly in view of the fact that it is being more excessively used in large number of cases for a longer duration. So these are some of the important human rights concerns. I'm not going into other human rights concerns as such, particularly because Professor G.B. Reddy has extensively discussed about some of the issues relating to how criminal laws are being invoked even to prevent movement of people. There are cases filed against laborers, migrant laborers, walking from their workplace because of the lack of work and livelihood options to their native places. There are criminal cases being filed or are sometimes threatened against them to prevent them from even going back to their native places when their livelihood is completely got disrupted in the place where they moved on to earn. So that is a matter of serious concern. What I tried to do is to flag some of the broader issues as to how these kind of legislations, which provides for drastic measures to be taken by the executive without any kind of a scrutiny by the legislature, are in fact the real threat to the human rights or the fundamental rights that we have in the country. So in conclusion, I would like to say that it is not appropriate to use these anachronistic laws with penal provisions to tackle the COVID-19 pandemic. No doubt, this extraordinary situation requires certain extraordinary measures, but keeping in view the need of the hour, it may be advisable to enact separate comprehensive legislation like in the United Kingdom to deal with the pandemic. In UK, most of you may be aware that they've enacted the Coronavirus Act of 2020 in the month of March to deal with the pandemic and challenges thrown up by it. Have a look at it if you have not looked at it, how comprehensive a legislation it is. And tell you the UK does not have even a written constitution, but even then they thought that unless they enact legislations like this specifically empowering the executive, they cannot, by laying down broader legislative framework, at least they cannot take such drastic measures. They even have specific provisions for closing of schools for a certain period of time because they thought that without a legislative backup, that the executive orders cannot be issued for closing of the schools and colleges there. So to that extent that they've gone into the into various aspects of it, into the minute details, they specified the state responsibilities, what the states can do, what powers that they have, how are they going to guarantee the rights of the people who are affected by it. Everything is laid down. And we should also have a similar legislation that is in conformity with our constitutional framework. And it is not proper for us to go on using this anachronistic legislations to penalize people when they actually need proper safety and protection. I'm not saying that no penal law should be used under certain circumstances, under any circumstances. In certain circumstances, use of penal law may be required to deter people from unnecessarily creating newer challenges to the governance in this crisis period. But we need to have a proper law, and we can't use this anachronistic legislations like Epidemic Diseases Act of 1897 and the Indian Penal Code, particularly the provisions like Section 188, which penalizes or which makes Disobedience to the executive order a punishable offense. That is too drastic a provision to be used and too vague. So when a provision is too vague, it is more likely to be abused. So we should think of, actually, even Professor G.P. Reddy has pointed out that legislature has not done anything during this crisis period. Perhaps it is time for the legislature to think of enacting law on the lines of the Coronavirus Act of 2020 that the UK has enacted. With this, I end, and thank you all for giving me this opportunity, and I thank all the participants for their patient hearing, and I look forward for any questions or clarifications at the end. Thank you.
Thank you, Puneet.
Thank you, sir, for the very informative speech. Now, I would like to invite Dr. Anish V. Pillai. Sir has studied BA LLB honors in Mahatma Gandhi University. Sir has passed LLM with specialization in human rights law and consumer laws from Cochin University of Science and Technology with first rank and 2 gold medals. Sir has also obtained his PhD from Cochin University of Science and Technology. Sir has published 2 books and edited several chapters in various books and has also published 20 articles. Sir is currently a faculty in the School of Legal Studies, Cochin University of Science and Technology. Sir will be addressing the topic Importance of International Human Rights During the Pandemic. Over to you, sir.
Esteemed professors, Professor G.B. Reddy, Professor Suresh Nadagowda sir, Professor Sudesh sir, Professor N. Desharath, Professor Puneet sir, and Subramaniam sir, and Coordinator Professor Satish Gowda sir. It's a privilege for me to be with this galaxy of academicians and speak a few words about the importance of human rights in a pandemic situation. I'll just share my slide, then I will start. I think my slides are visible.
Yes.
Visible? Yeah. So today I will be focusing on the issue, how important international human rights during this pandemic situation. So I would like to start with a question. What was the reason for human rights violation due to this pandemic, COVID-19 pandemic? Is it COVID-19 pandemic, or is it the lockdown and its enforcement due to COVID-19? Now, if the answer is COVID-19 pandemic, then I would say whatever human rights violations were happened, that is because of the act of God. Not in the sense of emotional way or religious way, in the sense of the civil law defense act of God, because it is an act of a natural force. Now, if the answer is the lockdown and it's the way in which the lockdown is enforced using criminal machineries or criminal law and the enforcement machineries, then my question is whether the imposition of this lockdown and the way in which it is enforced are in tune with India's international human rights obligations. So this is the question which I want to discuss in the entire presentation. Now, before starting with this, answering this question, first of all, we have to be very clear about what obligations India having with respect to human rights, international human rights. Now we have articles like 51C, 73 and 253 of Indian Constitution. These 3 articles somewhere, one way or other way talking about international law, but it does not give an answer to what extent international human rights law is applicable in India and what are the obligations of India. Now, this particular point was discussed in a number of cases. I think everybody is aware of that, like Mahanbhai Patel, Gramophone Company, Vishaga, etc. And the sum and substance of all these case law and the joint reading of this case laws with the articles, we can come to the conclusion that unless and until the judiciary or the legislature has adopted an international human rights document, that will not have any effect in our country. Our country is not bound to follow it. Now the question is it judicially incorporated? Now we all know the dicta of Vishaka. If there is a legislative gap, the judiciary can very well refer. Now, at the same time, another question, is there any legislative act which incorporates international human rights law into India? Now, you see the Protection of Human Rights Act 1993. In that, this act defines what is human rights under section 2D. That definition very clearly says all those rights guaranteed under international covenants and enforceable through court of law and other documents which are ratified by the international, which are notified by the central government. Now, the definition, the word international covenants used in section 2D is given a definition under section 2F. Now, this international covenants, what are international covenants? The terminology used in this Protection Act, Human Rights Protection Act, indicates the international covenants on civil and political rights, as well as international covenant on social, economic, and cultural rights. Now, with respect to ICESCR, it is not mandatory because that convention itself says it is not mandatory. It is based on the financial status of the country. But when it comes to ICCPR, International Covenant on Civil and Political Rights, that is binding to all the member nations. Now, as per section 2D of Indian Act, the human rights in India means all those rights which are listed in ICCPR. If that be the case, Indian government having an obligation to protect and enforce all the rights listed under ICCPR. Now, with respect to the question, those rights which are in UDHR. Now, one thing we have to remember, almost all the rights there in ICCPR is there in UDHR also. And UDHR, very only 3 or 4 rights are missing or added in the UDHR, in the ICCPR. Now, with respect to the application of UDHR, we have judicial decisions like case on the Bharati onwards, wherein the Supreme Court has highlighted or stated very clearly UDHR is also applicable in India because it talks about natural rights of the people. So, what I want to say is Indian government having an obligation to protect the rights, human rights, international human rights, guaranteed under or listed under ICCPR and UDHR. Now the question is, what sort of violations happen during lockdown? Everybody know what are the various rights which are violated, rampantly violated because of this lockdown and its enforcement. Right to liberty, right to movement, right to assembly, right to livelihood, right to food, health, work, education, etc. etc. There's a long list of human rights which are violated due to this lockdown and its enforcement. Now, whether these violations, that is in the name of lockdown and its enforcement, is justifiable in the eye of international human rights law. Now, I said in the beginning, all the rights listed in ICCPR is applicable in India, Indian government having an obligation to enforce it and give effect to that. Now, whether ICCPR allows any permission, whether ICCPR permits any sort of violation or restriction of rights guaranteed under that particular convention. Now, ICCPR itself says under Article 4, there are certain circumstances, the rights guaranteed under ICCPR can be violated, can be derogated, or can be nullified by the member nations. Now, that is what derogation of human rights under Article 4. But Article 4 says that a country or a member nation is entitled to derogate a human right only if there is a public emergency which threatens the life of the nation. And the existence of that threat or public emergency should be officially proclaimed by the government. Now, the question is, in India, we have imposed lockdown. As a result, we are violating the rights guaranteed under ICCPR. Whether is it in accordance with Article 4 of ICCPR? If it is not in accordance with Article 4, it is a violation of India's obligation under international human rights law. Now, what is now the point is whether there is any public emergency in India. Maybe we may say there's a health emergency or a health crisis, but there is no public emergency. And we have a constitutional provision which talks about declaration of public emergency. Unfortunately or fortunately, government has not resorted to that. And there is no official proclamation also in that regard. If that be the case, we cannot bring Article 4 in our lockdown situation. Then what Indian government, through proclamation of this lockdown and its enforcement, done is clear-cut violation of rights guaranteed under ICCPR and violation of obligations under ICCPR. Now, one point I'm not remembering here, I'm not forgetting here. Recently, there was a question, the same discussion was happened in some other countries, and one of the representatives from a country asked the same to the United Nations. United Nations has opinion that this particular COVID-19 pandemic crisis can be considered as something which threatens the life of nation. Now you can get all the details in the Google. It is very well available in the Google, that particular statement of the United Nations. So accepting that, what United Nations is saying, this particular COVID-19 pandemic is a threat to the life of the nation. Then if that be the case, we can bring this particular lockdown under the heading of Article 4 of ICCPR. So our action, the government's action, will be saved under Article 4, only because UN has stated it is a crisis which threatens the life of nation. Now, for that, we have the background, the well-known maxims like Salus Popula Suprema Lex. The welfare of the people should be taken into account always. But when there is a when there is a threat to the life of the nation, then the new maxim will come into picture, Salus Republica Suprema Lex. That is, life of the nation is prime rather than the welfare of the people. So in that condition, or in that way, we can justify to an extent the act done by the government in way of lockdown. Now, one more point here we have to remember, though ICCPR allows derogation in the name of public emergency or a life-threatening situation, threat to a life of the nation, it clearly says there are certain rights which cannot be suspended or restricted or violated even in a public emergency situation. That is what under international human rights law we used to call it as non-derogable rights. Those rights are Articles 6, 7, 8, 11, 15, 16, 18, etc. But in that, one particular right, that is Article 7, which is a non-derogable right, and that cannot be violated or restricted under any circumstance. Even in public emergency situation, country having no right to restrict. That is right against cruel, inhuman and degrading treatment or punishment. Now look at the way in which this lockdown is enforced in our country. We have seen the public beating by the police using lathis and other measures. It's a clear case of violation of Article 7. So even when we are justifying the act of lockdown or proclamation of lockdown in the name of derogation of human rights under Article 4 of ICCPR, but still we have violated Article 7, that is right against cruel, inhuman or degrading treatment or punishment. And that point we have to keep it in mind. Now, when I'm saying all this, automatically a question comes, why we are worried about international framework? We have a well-established constitution. That is our suprema lex. So we have to look into the justifiability only on the angle of Indian constitution. Now, take the case of Indian constitution. Does Indian constitution acknowledge or allows Indian government to issue a lockdown? And whether it permits to enforce the way in which they enforced it. Now, first of all, you have to see all the human rights, all the fundamental rights and constitutional rights, except one or two, can be curtailed when there is a public emergency officially declared. Now, as of now, there is no such public emergency officially declared using 352 or 360 or 356. Okay. Now, if that be the case, then next question is violation of various fundamental rights using lockdown is justifiable on the basis of Indian constitution. Now take the case of the most important right which is violated, that is right to liberty and the associated rights. Under Article 21, this right to liberty is guaranteed with a covenant. It can be violated when there is a well-established procedure established by law. So if there is a procedure established by law, right to liberty, which is guaranteed under Article 21, can be legally restricted. Now, take the case of lockdown, how it is declared. This lockdown is declared as per the provision of, as per Section 6 of Disaster Management Act 2005 by the Home Secretary. Now, when there is a legislation which allows taking a measure which violates a fundamental right, does that legislation will satisfy the test of constitutionality? That is a big question here. Now, whatever notification is issued under Section 6, it should go in hand with fundamental rights of the people. If it is going against fundamental right of the people, then Section 6 will be unconstitutional. That can be an argument. So in that situation, curtailing liberty on the basis of Disaster Management Act is not permissible. Then comes the question of freedom of assembly. That is another major right violated due to lockdown. Now, from where we are getting freedom of assembly? That is from Article 19, Clause 1. Now, Article 19, Clause 3 very clearly says under what circumstance government can restrict our freedom of assembly. Unfortunately, a health crisis is not a ground mentioned under 19 Clause 3. Now, if that be the case, violating freedom of assembly due to this pandemic through lockdown is unconstitutional. Then freedom of association. Again, this is guaranteed under Article 19(1) and the restrictions are there in Article 19 Clause 4. Now, none of the grounds mentioned in Article 19 Clause 4 is applicable in our pandemic situation. If that be the case, again, violating freedom of association is also unconstitutional. Then freedom of movement, that is the most important thing. We might have seen the plight of migrant laborers also. Again, the specific grounds for restricting freedom of movement of an individual in India is given under Article 19 Clause 5. Now, none of the ground talks about a health crisis like a pandemic situation. Then freedom of profession, occupation, trade and business. Article 19 Clause 6 very clearly says these are the grounds through which government can validly curtail this right. But health crisis is not a valid ground. Then how the government can impose lockdown, thereby restrict all these human rights, though we are calling it as fundamental right in India? That is the million-dollar question which I want to raise here. Then some people used to cite Epidemic Diseases Act 1897 as a reason for, but unfortunately we have to see that for issuing lockdown and subsequent extension, the government has not used Epidemic Diseases Act 1897. Even if this lockdown notification was issued under Epidemic Diseases Act, still that act would amount to unconstitutional, because that will also violate our fundamental right, because none of the legislation can allow the government to take measures violating the basic fundamental rights of the people. So if that be the case, then why people are not criticizing against the imposition of lockdown? I have only one answer, that is necessity knows no law. And people are under the impression that lockdown is the only option to avoid spread or flatten the curve of this pandemic. So maybe that is the reason why people are not raising their voice. There were no writ petition challenging the lockdown, or something like was not seriously filed. So in conclusion, I want to highlight one point. Whether all these violations of human rights happened in India due to COVID-19 pandemic as a result of lockdown, and the way in which the lockdown is enforced is justifiable in accordance with international human rights obligations of India. If our answer is yes, if you all are agreeing with me, then I want to highlight the thing: we need to develop a framework with introducing necessary changes in the existing law, so that in future this type of situation comes, we can effectively deal with, or legally deal with, not illegally. And we no need to take help of age-old maxim, necessitas non habet legem, for a governmental action. So by this I conclude. I will be happy to answer or explain any point which I raised in my talk. Thank you very much for listening me and giving me this wonderful opportunity. Thank you.
Thank you, sir, for the enlightening speech. We now move on to the much awaited question and answer session. So the first question is by Dr. Satish Gowda to Professor Dr. G.B. Reddy. Sir, the question goes as follows. Whether PIL can be filed against union government to direct all the state commissions like State Human Rights Commission, Women Commission and Commission of Children to discharge their statutory duties effectively and efficiently during this pandemic in order to ensure the rights of women, children who are in the vulnerable section.
GB Reddy sir here, sir.
Doesn't look like sirs here.
Yeah. Please ask next question to
Okay, sir.
other. Yeah.
Oh, so okay. So the next question is by Miss Tanishq Toor to Dr. Anish V. Pillai. So the question goes as follows. If a country would want to go ahead with herd immunity in contrast to a lockdown like the UK had tried, would it also lead to violation of human rights of the people and an abdication of the duty of the government?
Right. No doubt in that. No doubt in that. See, when I am saying when I am criticizing the way in which government enforced the lockdown, it is only because it is not in accordance with the legal provisions. And it is only because the absence of legal provisions. I'm not saying lockdown is effective or ineffective or anything, or lockdown is an expected method or not to contain the diseases. Okay, but only I raised the question, when government is taking a measure, it should be backed by a law. It should not be against the existing legal principles. It should not be against the fundamental obligations of the country under international human rights. That's the point I was raising. Yes.
Thank you, sir. Thank you.
Hello.
Thank you, sir.
I am Professor Dashrath, sir. One question to Professor G. Reddy. May I ask you, sir? Hello?
Sir, Professor G.B. Reddy, sir, is not in online. Hello.
He is not in line, sir. So, okay, shall I pose one question to Professor?
I think G.B. Reddy, sir, is there. I can see his screen.
Yeah. Now, you can
Professor
ask.
G.B. Reddy, sir.
1 minute. Yeah.
Professor G.B. Reddy, sir, am I audible, sir?
Sir is there, sir, but sir is dormant.
Okay. May I ask one question to Professor T.R. Subramaniam, sir? Chair.
Yeah, please, sir. Proceed, sir.
Sir, respected Chair, Professor T.R. Subramaniam, sir, my question is that you have referred to the Kelsenian support for the non-binding of the international instruments for the nations. But when he expounded that pure theory of law and came with a very special norm, the grand norm, Mr. Kelsen was asked, sir, what is the sanction for your grand norm at the international level? I believe the answer given by Kelsen was that the sanction for the grand norm at the international law is the Security Council that can come into play for enforcing the sanction. Am I right, sir, in this way? Number one. And number second, sir, in the recent times, what is happening is that the international institutions at the United Nations level and at the central level, the National Human Rights Commission, the State Human Rights Commission, and many other commissions have been undermined like anything. They are questioning their existence, their veracity, their functioning, all that. So is it a proper for this type of thought going on in the country at the domestic level and at the national level, sir? Over to Professor, over to sir, Chair.
Unmute ಮಾಡಬೇಕು ಪ್ರೊಫೆಸರ್ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರಿಗೆ.
Please unmute.
ಆಗಿಲ್ಲ.
My question was audible, sir.
Yes, sir. Now you can. Subramanian, sir, you can speak now.
I did answer. Now,
please, sir.
All the speakers, they pointed out one glaring lacuna has emerged, and including with the Professor Dashrath's question. That lacuna is most of our parliamentarians or the lawmakers, when they speak in public forum, they speak about cooperative federalism. And in this case, in the COVID crisis of 1919, actually constitutional federalism is lacking. That is the first point. The second point is there is only one instance in the whole world as on today. That is the state of Australia. The state of Australia, as and when the COVID-19 occurred, immediately they constituted a national cabinet. And the national cabinet actually is composed of the 6 premiers of the region, as well as the 2 chief ministers of the Australian territories. And all of them meet together and they take a decision by consensus. What ought to have been done is the same pattern or the same analogy should have been adopted by the government of India. That was not done, one aspect. Now, the second important thing that is being spoken here happened to be the legislation which was adopted by the state of Great Britain in March in 2020. Immediately the legislation was passed. There were public opinions saying that the government of the day may abuse the power. Human rights will be violated. So soon, the government of the state of Great Britain brought an amendment to the COVID-20 legislation saying that every 6 months, the COVID legislation of the state of Great Britain of 2020 is subject to review. That is the way they went to the extent of guaranteeing human rights to the people. In our country, this cannot be thought of, one aspect. Now, the other important thing is regarding judicial activism. Now, Professor Reddy as well as Professor Pillai spoke about judicial activism. It's a question that came up before. The courts in developing countries, whether the Supreme Court or the apex court in this country should take up all matters. So when this came up, the Supreme Court in one of the decisions pointed out, we will take up only urgent matters. The question then came, what are urgent matters? Now, whether a bail petition is an urgent matter, or whether a hearing relating to what we awarding compensation in a death case or in any other contract case is an urgent matter, or whether protecting the children is an urgent matter, or protecting what we call as the poorest to the poor is an urgent matter. This came up. Now, in all these things, the Supreme Court, as to say, with apology, has not acted very judgments you don't have in clear terms. Only in the recent past, you have 1 or 2 judgments, but that is not enough. I just intend to quote you a famous judgment which came about the Constitutional Court of Ecuador. Ecuador became the most victim in the COVID-19. Thousands of people died. There was no place to bury the dead bodies. You must have seen, especially in the world news, how the people were suffering. But at that time, it went to the extent of saying, in defining what are urgent matters. So the Constitutional Court at that time pointed out access to medicines and food. It is an urgent matter. And it has to be, the petition has to be entertained by the court of law on priority. Access to food and medicines. The second one is protection of the vulnerable people. When I speak about the vulnerable people, 13 crores of people have been moving from place to place, from state to state, and they have slept. There are instances wherein people from Mumbai to Mangalore have walked, and even in circumstances like this, there is nobody to protect them. And they have to be protected and they have to be taken care. That is protection of vulnerable people. Then entry to the country of nationals or residents remaining outside Ecuador. When I speak of this, you think of the people in the Gulf countries alone, there are 35 lakhs of Indians. And they are serving as maid servants, men servants, working in municipalities and holding professional jobs. You must have read in the last 2 days, in the state of Kuwait itself, there are 7 lakh Indians. The population is more. It is almost near about 10 lakhs. 7 lakhs of them are going to be sent, of which 4 to 5 lakhs of them are of holding jobs which are not a very good job, working in corporations, maybe sweepers, maybe working in the house of sheikhs, maybe maid servants. Now, their concern is also an emergent matter. Now, there are instances, I can just tell you because I know personally, parents were invited by their children who are working abroad, and they have gone there to spend their holiday.
because these parents are retired people. Their visa has expired. They want to come back. The government, if they are not going to rescue them, who else will they rescue? It is the duty of the government of the day to rescue such people. One. The second one is, in addition to the parents, certain children have gone there. Sisters who have gone there have become pregnant. And remember, they need medical help. Those who have read constitutional law will also know there is a petition which was filed before the Supreme Court of India by a lady who was pregnant in Qatar. And she wanted to get back to the country immediately. And the Supreme Court heard the matter and reported to the Ministry of Civilization to bring her back on priority. That is why the first flight came from Qatar. And there were several pregnant women. These are instances, and these are instances relating to the vulnerables. They may be abroad, but then it is the duty of the government of the day to speak about international law. It is the state which grants nationality. And when the state grants nationality, there are duties and rights which overflow reciprocally. And it is the duty of the state to protect its nationals, because when they declare themselves as nationals and owe allegiance to the country, and the country has issued them passport. And if this is not done, who else will do? No one is going to rescue them. Now the other thing is protection of first-line public servants. Now corona warriors. Now you know every day what is happening. Some of them are beaten up in Delhi and other places. In Bhopal, they were beaten up. And if they are not going to be protected, as of now, I can just tell you, there is a shortage of doctors, which is to the tune of 6 to 7 lakhs in this country. And if patients, remember, 25,000 of the patients are admitted on day-to-day basis as corona patients. Who is going to treat them? And if you will treat them, what is going to happen? Now, they need to be protected on priority. Otherwise, the whole thing will fall to the ground. Then, the other important thing, access to justice and constitutional remedies by the population. So when constitutional remedies are to be enforced, such people and such cases are to be heard by the Supreme Court of India. This is what it was said. Now, simultaneously, there was another case which came up before the courts in Australia, in South African court. South African court was also asked to decide what is an emergent matter. So even in South Africa, there was mainly shortage of drinking water. When there was a shortage of drinking water, the state of South Africa, the Supreme Court went to the extent of saying that they defined what is an urgent matter. A bail application is an urgent matter. And appeals or matters relating to violations of liberty, it is an urgent matter. It has to be heard. Matters pertaining to domestic violence, it is an urgent matter. Matters pertaining to maintenance, it is an urgent matter, because if maintenance is not given, it will hit the stomach. Where will they go? From where will they bring the money? And they have to be catered. And matters involving children. Children are the future citizens of this country. They are to be protected. This is what the South African Supreme Court went to the extent of pointing out what is an urgent matter. These are very educative, and every court in this country should emulate, and we have a lot of inspiration from these decisions. And regarding the last point, it is Professor Desh's question. Now, Kelson, remember, essentially a logician. The whole theory of law is based on one rule is conditioned by another rule. So the municipality of a particular state enacts a rule depending upon the laws which are enacted by the state. The state enacts and emulates a particular rule depending upon the law enacted by the state. The law which is being enacted by the parliament is conditioned to the constitution of that state. The basic question is, now beyond that, that is the fundamental premise. Above the constitution, whether the whole rule is not concerned with ethical principles, moral principles. That is where the Kelsenian theory was defeated. His student, Professor Lotterpat, was a professor of international law at the University of Cambridge and became a judge in the International Court of Justice, points out that the whole theory, remember, gets defeated because of the ethical principles and the moral principles which his guru spoke about. Because no law can be there. And no law can be enacted by a parliament without taking into consideration the ethical and moral considerations in a role. Thank you very much.
Yeah, my question to Dr. Puneet, may I?
Yes, sir. Yes, sir.
Yeah, Puneet, thank you for a very insightful presentation. And I also thank the chair, Professor Dr. T.R. Subramaniam. Both of you have touched upon the theories of law directly or indirectly. So I'm tempted to ask this. Well, most of us academicians have been very critical about the executive action taken on ground under the garb of several legislations, understandable. But we find also that in our neighborhoods, people themselves have taken to impose curfew and to be self-policing under IPC, etc., etc. Speaking for the government and speaking on the basis of the theories of law, good that you referred to what UK did in enacting the COVID-19 or coronavirus legislation. So my question to you is, what is your suggestion proposed, if at all, the government of India or the state governments undertake to enact a separate legislation? Do you think, keeping the population of India in mind, the theory, the concept of law developed by Austin would work, or any of the sociological theories would work, or a combination of both? Number one. Number two, do you advise that the state governments have a separate law and the central government has got a separate law? If the state governments have a separate law, then, for example, the UP government says that no, we will not allow our laborers to move outside our state, or we will not allow, like Bihar says, we will not allow laborers from other states to come in, and they enact this in the coronavirus legislation. What is your idea on this? Especially special emphasis on the Austinian concept of law. Law is the command of the sovereign.
Thank you, sir. As regards the theories of law are concerned, I do not particularly endorse any particular theory as such. I am a kind of an eclectic who believe that it is the combination of all these which gives a truer understanding of what law is all about. And particularly when we speak about the law to be enacted by the state as such, we are thinking of a kind of a formal law to be enacted. It might be somewhat akin to what Austin say, law with sanctions for the enforcement. But when it comes to the question of whether the state or the center should enact, India is a vast country and there is so much of a diversity that exists, no doubt. And what adds to this complexity is the fact that the public health is a state entry under the 7th schedule of the Constitution of India, whereas certain subject matters relating to quarantine and other things falls within the union, the concurrent list. Given the fact that we also need some kind of a uniformity, I would say it is better under the circumstances to for the states to pass resolution under, I think, Article 252 of the Constitution to empower the union to enact a legislation for the to govern the entire aspect of COVID-19. But the union legislature should lay down a broader legislative framework while leaving some rule or regulation making power to the states concerned to address the specific issues that they have. That is the one important aspect. And the second important aspect, as Professor Subramania also pointed out, that how UK has brought in an amendment subsequently when the Coronavirus Act of 2020 was criticized. I think even in India, whenever such extraordinary laws, no doubt when the law is enacted, particularly to deal with this kind of crisis situation, they would definitely confer some of the extraordinary powers in the executive. But what I am trying to say is that when compared to the earlier laws, where such extraordinary powers have been conferred without any kind of parliamentary oversight or a legislative oversight, we should contemplate a law which confers the powers that are needed to deal with, which is in conformity with the Constitution, which also provides for a legislative oversight as to what kind of orders, rules, or regulations the executive is going to make. So that is going to be an extraordinary law. But whenever such extraordinary laws are enacted, it was the trend even in India, even before, when you look at some of the extraordinary laws like preventive detention or the TADA, those legislations came up with a sunset clause. That is what Professor Subramania has said. In UK, they introduced a sunset clause. Every sunset clause in such legislation requires that these extraordinary laws needs to be periodically revisited to see is there any justification to continue such legislation for a further period. If so, for how long? does it need some modification, some relaxations or so? So when we think of enacting an extraordinary laws, particularly the union legislature enacting, it is more appropriate, and it can do so by leaving enough scope and space for the state legislature or the state government to fill in the specific aspects keeping in their need. But it should also come up with a sunset clause in the sense that it also, like in the case of UK, that this law may have to be reviewed every 6 months. And unless they're reviewed, like earlier, the Preventive Detention Act, I think always emphasize on this aspect whenever I speak about the extraordinary provisions in India, that most of them have become now the regular features of the Indian legal system. Like TADA initially came with a sunset clause, and every 2 years it was reviewed. But now when POTA came and now the UAPA, it became a permanent feature. The Preventive Detention Act came with a sunset clause. And now when NSA came, National Security Act, to which I refer to, it is a permanent feature of India's legal system. So we should not make this extraordinary laws a permanent features of our legal system. They should be enacted as and when the time requires to deal with the circumstances and the specific challenges. And such law should mandatorily have a sunset clause. This is my brief response, sir. I am not sure whether it satisfied your query.
Reddy. Professor G.V. Reddy is online, sir. Sir, G.V. Reddy garu. Namaskaram, sir.
Sir, I am online. Yes, sir.
Sir, your presentation was very appreciable, with full of juristic thoughts, sir. Sir, my one very humble question is that you said that neither the judiciary sometimes acted responsibly, sometimes it acted irresponsibly, and so also is the government, sir. Is it the right time, sir, that especially the health and education in our country are to be revisited to see that these very service sectors, education and health, should be nationalized? Because I feel that the nexus between the rulers and the ruled in this sector is ever increasing and is not going to stop in near future. So is it the right time, sir, to revisit and relook and rethink that these two vital service sectors, health and education, should be nationalized?
Yeah, in fact, I appreciate your question, sir. I'm sorry that I was away for about 10 minutes. In fact, I was speaking to, no, I was speaking to a learned judge from AP who was on one of the tribunals on interstate water disputes. And incidentally, he was mentioning about a constitution of a committee consisting of 3 judges in Delhi to look into some of the aspects of educational institutions. And he was saying in private, I'm not mentioning the name, that out of those 3, 2 are associated with running their own institutions. What I'm trying to say is that there is an unholy nexus, very unfortunately, between the government, sometimes even the private sector and the subjects also. Maybe it is high time, but at the same time, nationalization may not be the effective solution, sir, because we have seen what was nationalized before. Now today again it is denationalized. We have already seen that. Maybe the other avenues, like probably in fact making this education a central subject. That's what you are trying to say. Yeah. Similarly, maybe the health, but at the same time, public health is something from which the states cannot be totally excluded. Education, yes, but health, I have my own doubts, sir. Practically speaking, if it is nationalized, nothing like it. But public health still continues to be a state subject. That's the problem, sir. Thank you, sir. Thank you, sir.
So I would like to seek clarification from Dr. Puneet.
Yes, sir, please.
Okay, so in your presentation, you have stated that UK has enacted a separate law to deal with the pandemic situation. So I just would like to know whether you are aware that in Karnataka, they have brought a separate, the Karnataka Pandemic Diseases Ordinance to specifically to contain and regulate the COVID-19.
Yes, sir. In fact, I'm slightly aware of, in the sense that I do not.
Is it audible?
Yes, sir. Yeah. No, I'm slightly aware of, but I do not know the details of it. Details, specific provisions of the Karnataka legislation. But I know why this act was brought. It is because of the fact that initially they started using the power under the Epidemic Diseases Act of 1897 without knowing that the act did not apply to the princely states. It did not apply to the Part B states at all. And the Karnataka government could not have used the power under Section 2 of the Epidemic Diseases Act of 1897. And the moment they realized that, then they came up with the ordinance. But unfortunately, I have not looked at the specific provisions of the act, sir.
Yeah. They have also exercised the powers under National Disaster Management Act.
Yeah, that they can do. National Disaster Management Act. They can.
And apart from that act, they have specifically enacted this. I think not only Karnataka, even a neighboring state like Kerala also enacted a similar legislation brought in the form of ordinance.
Most of the princely states might have done it simply because of the reason that the Epidemic Disease Act of 1897 did not apply to the princely states. They had to enact a specific law to use the similar powers that are granted under the Epidemic Diseases Act of 1897. But I do not think, but I'm not looked at it, I cannot comment upon the how properly and how comprehensive.
Not audible.
Can it be? Hello, sir,
Sir, it is audible. Please.
Can you hear me now?
Yes,
Okay,
sir,
Puneet.
yes.
Yeah,
Thank
I'm not looked at the specific provision, so I cannot comment on the merits of the legislation as such. Thank you.
You can just go through the ordinance. It is very clear and it empowers the government to take necessary measures to contain and regulate the pandemic like this.
That is what even the Epidemic Diseases Act does. It is a skeletal legislation like that. It cannot be compared with the UK Coronavirus Act, which is very.
But the Karnataka ordinance is a very comprehensive one. It contains provisions and it empowers the district authorities and all to exercise necessary measures, to take necessary measures to contain and regulate the COVID.
Yeah,
and epidemic diseases.
There are 17 sections. In fact, Section 16 repeals the 1897 Epidemic Disease Act in the Karnataka Ordinance. By invoking Article 213, they promulgate it.
And one more in this connection, it is to Mr. Pillai, Anish. So he was stating that under Article 19, there is no scope for, there is no provision to curtail the rights of the people, particular rights of movement, as the aspect of health is not mentioned therein. In that case, what will be the validity of this ordinance, which is brought in by the state?
Definitely, sir. If somebody will challenge before the court, it will be considered as unconstitutional. No doubt in that. Because our constitution very clearly says every person has a freedom of movement, freedom of profession, freedom to trade, sale, etc. But and how it can be restricted. Constitution itself says these are the grounds in which government can do it, and that restriction should be reasonable. Now, when health crisis is not mentioned as a ground, how the government will be able to justify it?
I would like to have the comments of. Okay, I would like to have the comments of Dr. Puneet also on this.
Yes, sir. To plainly speak about it, public health is not a ground to restrict any of the fundamental rights under Article 19 of the 19(1) of the Constitution of India. Number two, that whether or not such laws that impose restrictions violate the constitutional guarantees, it depends on what test are we going to apply. If you apply the direct effect test, then the result would be different because these laws are not essentially enacted to impose restrictions on movement. They are enacted for a particular purpose to achieve a different purpose, and its incidental consequences on the movement. Consequence will be different. Second important aspect, if I were to look at one of the complex questions, actually, when we look at freedoms under Article 19 and the restrictions from class 2 to class 6 of the Constitution, the one question that would arise is whether the grounds of restrictions that are envisaged under the Constitution are exhaustive, in the sense that no other grounds can be used for imposing additional restrictions on these freedoms that are guaranteed. If you look at cases like Muhammad Ali Qureshi, say for example, where there was a restrictions on cow slaughter was imposed, they, in addition to the grounds under 19.2, they also 19.6, they also relied upon directive principles of state policy. If you look at freedom of speech expression, in addition to the grounds, contempt of court is a ground, but parliamentary privilege is not a ground. But if you look at MSM Sarma, Kesu Singh, and many other cases, they looked at elsewhere. So in order to harmonize the freedoms with other constitutional provisions, they have in a way kind of treated as additional grounds on which freedoms can be restricted. It is possible, I'm not saying it is the right thing to do, I must make it very clear, it is possible for them to say, since protection of public health is also one of the aspects in the directive principles of state policy, they may bring that aspect into the framework of 19 and then uphold. It's possible to uphold. That's my views.
May I come in? May I come in?
Yes, sir.
Yes, sir. Please, sir.
And apart from this, even as Supreme Court has held it, right to health is a fundamental right under concomitant right under Article 21. And also, as we know, it is a basic human right.
Sir, GB Reddy sir wants to address. Please.
Needs to be addressed.
Yes, sir. Yes, sir.
Yeah, may I? Yeah. Sir, in fact, when we look at Article 19 1D, read with Article 19 Clause 5, in the interest of general public is clearly mentioned therein. So, once it is mentioned, interest of general public implicitly in public health as well. So, we don't require any specific restriction to be mentioned there. I think that is a proper interpretation in my humble view. This is to supplement what the other speakers are trying to say.
Nevertheless, it is a need of our to bring a specific word public health through amendment during this pandemic.
Maybe, yes. That could be one of the suggestions.
Sir, one point I want to highlight. This issue of public health is included as a specific ground in Article 25.
Yeah.
So that means our constitutional makers are aware of the fact public health can be a ground for restricting fundamental right. But they haven't included freedom of religion. So freedom of religion. So that means the makers are aware of the fact that this can be a ground for restricting fundamental right.
Okay.
But they haven't included this in 19, any of the clauses from 2 to 5. That is what I was highlighting.
But as Professor GB Reddy has rightly pointed out, the phrase general public interest is very wide, and it's there in also. And whatever the implementation of directive principles of state policy is also considered to be in the general public interest in Muhammad Ali Qureshi. So here also, if you read the 19 exceptional classes and the directive principles, I think that is sufficient enough. And instead of we should not unnecessarily amend the Constitution, it is a sacrosanct document. So when the existing provisions allow us, I think we should continue with that. But what is required is enact a law, a proper law, providing for imposition, impose restrictions which are considered to be reasonable and proportional. That is most important.
We have a question from the public. Now, I request Nayak to ask a few questions to resource person from the audience group, please. Nayak.
Yes, sir.
Please proceed.
Sir, we have two questions here which have been combined from Ms. Tanishk Toor and Bhuvaneshwari. And this question is for Mr. GB Reddy. Sir, so as you had previously mentioned that people cannot be compelled to go to designated hospitals and the issue of overcharging by private hospitals must be looked into, can even the private hospitals be compelled to have a ceiling on the charges? And one more follow-up question is that are you of the opinion that the judiciary as a whole has failed to take suo motu cognizance of private hospitals charging exorbitantly? Over to you, sir.
Yeah, it's a good question. In fact, there are some live examples, even from my state, that is Telangana, wherein the government has come out with a package, like, for testing so much to be charged by the private, with oxygen, without oxygen. And the judiciary may not control, but the government can certainly control, because the government has the power to control the pricing as far as these essential services are concerned. Therefore, like in the case of DPCO, Drug Price Control Order, where prices could be brought down, of course, except in the case of patented drugs, similar power can be exercised by the government. And if it is unreasonable, the courts will test. The courts may not impose, but the courts may compel the private sector to follow the government restrictions or guidelines or capping of the price, so on and so forth. This is a first issue. I think there is no ambiguity in this, and the courts can certainly come to the rescue of the patients to get affordable the treatment at affordable cost. This is very important. The fleecing can be, for example, when we regulate the fee for admission into educational institutions, the same thing can be done even in the case of treatment also. And the best example is in the case of Unni Krishnan versus State of AP. Remember 1993, where the court ultimately came out with certain guidelines regarding the fixation of the fee in admissions into educational institutions. Health also falls under the same category. This is one important aspect. The second one, if you don't mind, please repeat the second question.
Yes, sir. So the second question was, are you of the opinion that the judiciary as a whole has failed to take suo motu cognizance of private hospitals charging exorbitantly?
In fact, in our case, there is a hospital called Fever Hospital, which is a government hospital. One of the doctors became a victim of COVID. She joined in a private hospital, and there, since she was not ready to pay 2 lakh rupees, she was detained in that hospital. When she sent a video, from the hospital bed, the Telangana High Court took cognizance of that and ultimately directed the government as to the steps taken or why the steps are not taken so far. I think in many cases, the courts have been very sensitive and prompt. And maybe because since it is an issue, pan-Indian issue, most of the high courts have not responded. Some of them have certainly responded. Suo motu notice, cognizance has been taken, and the governments have been asked. Only problem is this: the court cannot monitor itself. It will be too drastic a step. But if the government, the court itself appoints some committee, high-powered committee, to look into these aspects, things would be different. But the government also must be a willing partner to do justice.
Yes, sir. Thank you so much, sir. Now we have a question from Mr. Arsalan Zaidi to Dr. P. Puneet. Sir, considering UK and India both thought following a similarity legal jurisprudence and are very different as far as constitution is considered, especially given that UK having unwritten constitution gives it more flexibility to make law and so on, but the same cannot be said with regards to India. When this is the case, how do we bring about implementation process of other countries with our own?
Thank you for this question. There are two things. Number one, that I did not say that we should enact the law which is completely identical with the UK Coronavirus Act of 2020. We should enact a law that is in conformity with the Constitution, number one. Two, that yes, it is true that the UK has an unwritten constitution and we have a written constitution. But it is not only true if you look at some of the recent developments. The Human Rights Act and the Constitution Reforms Act that are enacted in UK have the status of constitutional law to some extent, though not in the same sense in which it exists. The Human Rights Act provides a framework for testing the validity of other legislations as well. There is a limited scope for judicial review of legislations, like the Coronavirus Act of 2020, can be subjected to the scrutiny before the UK Supreme Court now to examine whether it is in conformity with the Human Rights Act of 1992 or so. But the only difference is when it comes to judicial review in India, our courts can, once it is convinced that the laws are in violation of the fundamental rights, our courts have the power to invalidate the legislation, whereas in UK, there the court cannot invalidate, they can only give a declaration that the provisions of the Coronavirus Act, I'm using as an example, are inconsistent with the Human Rights Act of the UK. Then it is left to the Parliament to take a final call. They can either continue the legislation or withdraw the legislation as such. So to some extent, what I'm trying to say is that even in UK now, after the Human Rights Act, the judicial review of legislation, of primary legislation, secondary legislations have always been subject to judicial review in UK as well, subordinate legislation. Even the primary legislations can be subjected to judicial review, but the judicial review is not as effective as in the case of India. And since, at least to some extent, that there is a scrutiny of legislation to see whether they're in conformity with the laws, there is not much difference, excepting for this aspect that our courts have a power to invalidate, their courts do not have the final call, because they believe so much in the supremacy of the parliament. Parliamentary supremacy is the core aspect of the British system, which is not true in case of in any of the constitutional democracies. So that is the essential difference between the two. But as regards respect for human rights are concerned, in a way, though in different way, that both legal systems expect that the laws enacted should be in conformity with the human rights. Thank you.
Thank you, sir. I now request Mr. Rakesh MT, student of University Law College, Bangalore University, to
before that, Mahima Nayak, before that,
yes, sir.
Naman will announce. Hello.
Yes,
Hello.
yes, sir. Yes, I'm here.
Naman, please.
All right, ladies and gentlemen, this is an announcement with respect to the next session. The next session is at 4 p.m. So the 4 p.m. sharp will be starting the next session. So before that, all are requested to log in, and here you go. So by 3:30, we request you all to start logging in, and 4 o'clock we are sharp. We are starting the session. These are the speakers, the chairperson and the speakers. And after that, 5:30 sharp, we will be moving into the valedictory ceremony. So all of you all are requested to start logging in from 3:30 p.m. Thank you very much. Over to you, Mahima.
Thank you, Naman. I now request Mr. Rakesh MT, student of University Law College, Bangalore University, to render the vote of thanks. Over to you, Rakesh.
Namaste. As we come to the end of technical session 3 of the day 2 of International Workshop on Protection of Human Rights during Pandemic, I deem it as a great privilege to propose vote of thanks to all who have helped us making this session such a resounding success. Heartfelt gratitude to all the respected resource persons who blessed us with their presence and took valuable time from their busy schedule. Firstly, I would like to propose hearty vote of thanks to our chairperson of the session, Professor Dr. T.R. Subramania sir, Dean, School of Legal Studies, CMR University, and former Vice Chancellor, KSLU, Hubballi. Thank you, sir, for gracing today's session and for your very interesting and thought-provoking address. I would like to thank our distinguished speakers, Professor Dr. G.B. Reddy, Professor and former Dean, Faculty of Law, Osmania University, Hyderabad. Sir, thanks for being here today and for gracing this session. I extend my gratitude to Dr. P. Puneet, Associate Professor of Law, Center for the Study of Law and Governance, JNU, New Delhi. Sir, we are really enlightened with your knowledge and presence, sir. I extend my gratitude to Dr. Anish V. Pillai, Faculty of Law, School of Legal Studies, Cochin University of Science and Technology. So, thank you for making valuable presentation and making this session very interesting and meaningful. I would like to express our profound gratitude to Dr. Suresh V. Nadagowda, Honorable Principal, University Law College, Bangalore University, and Director of this esteemed international workshop. I would like to thank our Professor Dr. Sudesh V., former University Law College, Bangalore University, Bangalore, and co-director of this workshop. And sir, thank you for your moral support and guidance. We are thankful to Professor Dr. N. Dashrath, Honorable Chairman, Department of Studies in Law and Dean, Faculty of Law, Bangalore University, and co-director of the workshop. I would like to thank the coordinator of the event, Dr. Satish Gowda, and Senior Assistant Professor, University Law College, Bangalore University, for gracing this session. A heartfelt gratitude, Dr. Jyoti Vishwanath, ma'am, Senior Assistant Professor, University Law College, Bangalore University, for gracing this session and for rendering the welcoming address. Finally, the wonderful participants who turned up in such a great numbers and participated overwhelmingly. Thank you so much for your cooperation and making this workshop a grand success. Thank you.
Okay, thank you very much. I too finally take this opportunity to thank the chairman and all panelists in this session and all the participants for their effective participation. Thank you very much.
Nadagowda sir.
Thank you, sir.
Sir, please brief about today's guest for valedictory session.
New everybody, you only tell.
Today we have a professor from US. She will be delivering the valedictory address, and also we have invited the present Vice Chancellor of National Law School of India University to address chief guest address, and Ponnanna sir, former Advocate General and our own alumni, Chairman of ULC alumni, Gautam Chand sir will be joining us. Please, I request everyone to join by 3:30 itself. We will have last session between 4 to 5:30, and immediately we start the valedictory program from 5:30 to 7. And please, no need to wait or no need to join between 2 to 3:30. Thank you. Thank you all thank you to all discourse person for giving wonderful discourse and intellectual opinion. Thank you, sir.
Thank you, sir.
Thank you very much.
Thank you. Naman?
I'm here, sir.
So what are the plans next?
So all good. Sir,